this summit. I'm going to say a few words, and then I'm going to listen. Listen for the day. I listened carefully to Verna. Thank you for starting the meeting in a good way, and the emphasis on listening. Ishkode. We are here to listen, and we are starting as we mean to go forward by listening, engaging, working together. And thank you, Grand Chief, for being here.
Prime Minister Carney held a summit today speaking with Indigenous leaders and groups around their concerns they have about Bill C-5, which the Liberal government passed a few weeks ago. Here's the first thing that I want you to remember. Under Section 35 of Canada's Constitution, which recognizes the rights of Indigenous peoples, the Supreme Court has clarified that the Crown has a duty to consult and accommodate when Indigenous rights are affected. The Supreme Court made that crystal clear in their 2004 ruling of Haida Nation versus British Columbia. Indigenous peoples is defined as First Nations, Inuit, and Métis. And what I mean by this is that the federal government does not consult Indigenous peoples within Canada just because they want to or they're doing it as a favor. They are doing it because it is the law. They are required to do this. With that said, navigating the consultation process is very complex. There is treaty and non-treaty nations. There is modern and historical treaties. Some nations have self-government agreements, some do not. Some nations have elected chiefs, some have hereditary chiefs, some have both. There are 630 First Nations within Canada, and the Crown's duty to consult and the extent of that consultation can vary from nation to nation. It can also vary from project to project depending on the impact of that project. But the courts have also said that the Crown must listen, consider, and adjust plans where possible. Now, in 2018, the Supreme Court ruled that the Crown does not have a duty to consult when drafting, debating, or passing legislation. With that said, Canada also passed a bill in 2021 known as C-15 or UNDRIP, which is the United Nations Declaration and Rights of Indigenous Peoples. Now, that bill commits the federal government to aligning their laws with the principles of UNDRIP. And UNDRIP does require the Crown to consult with Indigenous peoples before passing legislation that could affect them. Now, to be clear, Bill C-15 did not change any laws. It only committed the federal government to aligning their laws with the principles of UNDRIP. Now, Bill C-5 created a framework of how projects may proceed once they are put on a list and deemed in the national interest. Currently, there is no projects on that list. Once a project is added to that list and the Crown or the federal government intends to move forward with that project, they will absolutely have to begin the process of consultation with Indigenous peoples. It is also very likely that that consultation process will have to take place before they are even added to that list. As the Prime Minister has said in the past, in order for a project to be added to that list, they have to have a high likelihood for success. And in order for a project to be successful, they are absolutely going to have to engage in meaningful consultation in order to meet their constitutional requirements. But ultimately, it will be up to the Prime Minister to determine whether that consultation met their constitutional requirements. Because if it does not, taxpayers are going to spend tens of millions of dollars trying to advance these projects through the court system. And in many cases, the Crown has lost because they did not engage in meaningful consultation to meet their constitutional requirements. If you want to read any of the Supreme Court rulings or any of the bills that I spoke about in this video, I will email them out tonight in my news roundup.